In today's video, we will talk about plea bargains. Hello, and welcome to Ask Professor Price. I have been a lawyer for more than 35 years and a full-time professor for more than 10 years. People studying law or criminal justice, or working in the legal or law enforcement fields, need to know how plea bargaining works because the vast majority of criminal cases never go to trial. Many of them result in a plea bargain negotiated between the prosecutor and the defense attorney. Our criminal system could not possibly handle every criminal case going to trial. The system would collapse under a caseload like that, and defendants would have to wait for years for their trial, many of them in jail the whole time. So let's jump right into types of plea bargaining. Plea bargaining is a process in which the defendant pleads guilty, expecting a benefit like probation or a lesser sentence in some way. There are three kinds of plea bargains: charge bargaining, count bargaining, and sentence bargaining. Charge bargaining is when the defendant pleads guilty to a less serious charge. Count bargaining is when the defendant pleads guilty to some of the original counts and the prosecutor dismisses the rest. And sentence bargaining is when the defendant pleads guilty to the original charge, hoping for a lighter sentence like probation or less time in jail. The process of plea bargaining involves certain presumptions. Most legally innocent defendants' cases get resolved much earlier in the process, at the prosecutor's charging decision, at the grand jury stage, or at the preliminary hearing. So when they get to the point of plea bargaining, defendants are usually presumed to have some factual responsibility for the offense. Put another way, they're not presumed innocent. They might be guilty of something less serious, or they might be guilty but have an excuse, but they are not considered innocent. Another presumption is that all parties benefit from avoiding unnecessary trials because of the work, expense, and risk of trial. Several factors go into plea bargaining on both sides. If the seriousness of the offense is one of the primary factors, your offer from the prosecutor and the likelihood of the defendant accepting it will be very different if the person was charged with littering rather than murder. Another factor is the defendant's criminal record. If this is a first offense, or if they've never had a conviction for a violent crime before, maybe a property crime but not a violent crime, those will be factors that the prosecutor considers when putting together their plea bargain offer. Also, the strength of the prosecutor's case is a factor. If the prosecutor knows they have this person and they have all the evidence they need and it's all strong and admissible, they will have less incentive to offer a plea bargain, except to get their caseload more manageable. On the other hand, if they've just had pretrial motions and the judge granted the defendant's motion to suppress certain essential evidence, then the prosecutor's case against the defendant is not as strong, so they will be more likely to be willing to engage in plea bargaining. Certain cases are much more likely to go to trial instead of getting resolved by plea bargaining. Three of the most common cases that go to trial instead of plea bargaining are homicide, sexual assault, and robbery. Not all in the same case, hopefully. The prosecutor can't offer lenient plea bargain terms in these cases, so the defendant has very little to lose by going to trial. And they might get lucky and get a jury who is not wanting to convict anyone. So defendants are much more likely to roll the dice and take their chances in a homicide case, a sexual assault case, or a robbery case. However, there is a certain thing called a jury trial penalty. This is different in different jurisdictions, but sometimes juries penalize defendants for forcing the case to trial when the prosecutor has a very strong case and the defendant has no defense. Sometimes defendants are very clear and obvious during the trial that they don't have a defense, but they want their right to a trial. Well, serving jury duty is highly disruptive of a juror's life. They miss work, they're away from their families. It can be a significant financial burden because they aren't at the office or on the job. And they show their anger with harsher sentences than the prosecutor might have offered for a plea bargain. So there are potential consequences to a defendant demanding a trial even though they have no defense. Please hit subscribe and the thumbs up icon if you enjoy this video. Also, please feel free to share this video with people you think could benefit from the information. YouTube uses the number of subscribers, likes, and shares in its algorithm to determine which videos show up in search results, and the higher these videos are in the results, the more people I can help. Thank you. There are other factors beyond what the prosecutor considers at the plea bargain stage. There are things that the judge will also need to think about and often does think about. For example, they might consider whether the defendant waived their right to a trial. Also, is the defendant competent? By the way, on the waiver of a right to trial, the judge doesn't want to go ahead and enter into a plea bargain agreement just to have the defendant refuse to waive their right to a trial, so the plea bargain stage was a waste of time. Also, they want to know, is the defendant competent? If it is an issue of sanity, mental illness, or intellect, the defense attorney might exert undue influence to get the defendant to enter into a plea bargain so that the defense lawyer does not have to do the work of a trial. Also, the judge will be concerned about what type of plea the defendant is going to make. There are several types of pleas. There's a guilty plea, a not guilty plea, and a nolo contendere. A nolo contendere means I will not contest the charges. So the guilty plea is a plea that requires the use of what is called a Boykin form from Boykin v. Alabama. It's required to ensure that the guilty plea is voluntary. A not guilty plea often will not make a person eligible for a plea bargain. And a nolo contendere is also called the Alford plea, And it means that they will not contest the charges. In other words, they don't admit factual guilt, but the plea has a similar impact. And they can go forward with a plea bargain in most cases with an Alford plea. Also, in plea bargaining, there's a stage called defendant's allocution. This is where the defendant is allowed to make a statement to the judge after their conviction. In other words, if they pled guilty and the judge found them guilty, but before the sentence is imposed, the defendant can use their allocution time as an opportunity to express remorse, explain their actions, or ask for a lesser sentence. Please feel free to post in the comments your questions about criminal law or related topics that you would like to see covered in a future video. I cannot provide legal advice about specific cases or situations, but I can offer general legal information for educational purposes. Law students, paralegal students, criminal justice students, and pre-law students, as well as people working as paralegals or in the criminal justice field, are the main audience for these videos, but everyone is welcome to learn about American law and our legal system. Please remember to subscribe so you can get notifications when I post a new video. Subscribing won't cost you anything, but it can help me to reach and help more people with these educational videos. Thank you. If you liked this video, you might like the next video called Juries in Criminal Trials.